I've always hated bullies and institutional hypocrisy, and I wanted to be able to fight for victims of those two things, especially the people that couldn't fight for themselves. I like being my own boss, and I like being able to pick the cases that I'm going to pursue so I can dig into the people that I believe are deserving.
Welcome to Between the Briefs, a podcast by Steno. We're here to bring you practical tips, expert insights, and real conversations about the pretrial process, court reporting, and the legal technology shaping the future of litigation. I'm your host, Adrian.
And I'm your host, Joe Stevens. Whether you're an attorney, paralegal, or just curious about how technology is changing the legal industry, we've got something for you. Each episode will break down complex topics, share behind-the-scenes intel, and talk to the people leading innovation in and out of the courtroom. So grab a coffee and let's get into what's happening between the briefs.
Hello and welcome to Between the Briefs, brought to you by Steno. We're your hosts. My name is Adrian.
And I'm your co-host, Joe Stevens.
In this episode, we're thrilled to welcome Tyler Barnett, an experienced attorney at Yuhl Carr LLP. Tyler has made a name for himself in personal injury law, particularly with catastrophic injury and automotive crashworthiness cases, securing some of the largest verdicts in history.
With over 2 decades of experience in the legal field, Tyler has honed his expertise in advocating for injured individuals, successfully managing complex cases, and achieving 7-figure awards. He's also a passionate advocate for leveraging legal technology to improve outcomes for clients and streamline the litigation process.
Tyler, welcome to the show. It's great to have you with us here today. How are you doing?
Thanks for having me here today. Appreciate it. Good to see you guys.
Of course. So let's take the audience right to the beginning. What got you into law? And then once you were in, what made you want to go into personal injury law?
Well, I've always hated bullies and institutional hypocrisy. And I wanted to be able to fight for victims of those two things, especially, the people that couldn't fight for themselves. I like being my own boss, and I like being able to pick the cases that I'm going to pursue so I can dig into the people that I believe are deserving.
Tyler, when you talk about that, we're kind of probably going to jump ahead here a second, but picking the cases that are right for you, I feel like that in and of itself is a skill or something that has probably evolved throughout the time that you've been practicing. How has that changed, and what kind of things are you looking for when you're sizing up cases?
Yeah, I would say I turn down about 95+% of the cases that come in the door. Obviously, what I'm looking for at first is whether or not the case has merit. But the relationship that I'm going to have with the client over the duration of the case is going to be long, and it's going to be involved. We handle cases from inception all the way through judgment or settlement, whatever the case may be. And so I need to kind of gauge what kind of person this client is. Is it the kind of person that a jury is going to like and want to help? While that might seem overly simplistic, I think that really reflects the reality of how these cases are valued.
You sound like you have a very rigorous selection process, right? You want to make sure that they kind of check the boxes so that you have a solid case that can actually win in case favorably. Is there any circumstance where the person may not meet all the boxes, but with a little coaching, they can definitely you can get their case to where they need to be?
I think that happens a lot, and that's probably more often the case than not. I think the biggest concern I have when it just comes to gauging the psychology of a new client is if they have an overwhelming sense of entitlement, or if they have these grand illusions of what their case is worth. And I think a lot of times we find a disparity between what a client feels their case is worth versus how a case is actually valued in the world of other like-minded assets. And so ultimately it comes down to them trusting you, and you have to start in the beginning at earning that trust. And the only way to do that is by directly communicating with the potential client before the case is taken on, as opposed to having it delegated to a staff member, which is fine perhaps for some original intake. But in order to develop that relationship and that trust, the attorney needs to be hands-on from the beginning, in my opinion.
Has that always been the case for you, Tyler? I feel like I hear from other plaintiffs' attorneys that they give a lot of counsel to sort of new or younger practitioners at the beginning of their career about this very thing, about, not ignoring red flags in taking on cases, even if it might sound like it could be a promising case, that there needs to be some sort of fidelity to that process. Have you made mistakes in this department before?
I think I have, and a lot of times, you tend to be a little bit more forgiving if the case has tremendous value, because it's worth the extra headache. But when you have a client that wants to quarterback and micromanage every little thing that you do, that can be pretty laborious and arduous, especially if the case has some degree of complexity. So, getting involved early, making sure they know that they're well represented, updating them periodically on the progress of the case directly from the attorney, not from a staff member. I think that's the sort of thing that when it comes time to really, evaluating the case and the risks and the rewards of going to trial, I think they're going to trust your recommendation at that point, as opposed to just coming in and saying, hey, we've been working on this file for 2 years and, now it's time to take the money and run. That they're not going to be, listening with open ears to something like that.
Now, we talked about what made you want to go into personal injury law. How about just being an attorney in general? What really got you interested in the law from the get-go?
Well, I think it just started from the foundational premise of everybody is playing a game and nobody knows the rules. And so I feel like if you're going to be playing this game and being an adult living in this world, you got to know what the rules are. And from there, you can decide where you want to put your time and energy. So I think that was the very basic premise of going into law. And then from there, I did some really interesting work, and I was exposed to a lot. I worked for 2 different Superior Court judges, one in Santa Monica that did criminal work, and then a judge down at Stanley Mosque in Los Angeles that did civil litigation. And then during law school, I even did some work at the DA's office doing preliminary hearings, just so I could get exposed to everything and make sure that what I wanted to dedicate, my time to was something I felt was going to be worthwhile.
You didn't want to stay in the criminal side? This is coming from a criminal practitioner?
Yeah, that is a tough path. I mean, they're all tough, but I mean, that definitely poses unique challenges. And I was able to get, a lot of, early experience. I was able to see a lot with the exposure that I had. But I wanted to be in a position where I could decide what the cases are that I'm going to take on. You can't do that on the DA side or the public defender side. And so the shortest distance between those 2 points was more on the civil end of the equation.
Yeah, that makes perfect sense, Tyler. I mean, that ability to select cases, and, I've been on the public defender side, and I do not get to say no to those cases. In fact, I'm sort of expected to handle the ones that everyone else has said no to, which is a challenge in and of itself. Is there anything that you've taken from that criminal experience that you've had, lessons that you learned in that area that have really played a powerful role in your development as a civil attorney?
I mean, I think I went into it with a little bit of naivete, and it doesn't always work out the way it should. And a lot of times, I think that happens when you don't have counsel that is well versed in what they're doing, right? Or if they don't work up the case the right way, or if they have too many cases, then their client gets the short end of the stick. So I think what I've tried to do and model in my practice is not become too big. We're a boutique trial practice. We handle the cases from the beginning all the way into the end. And I think with that, there's a lot of advantages. I can give my personal cell phone number to all my clients. We can be accessible. And the downside is I give my cell phone number to my clients and I'm pretty accessible.
Now, I know a lot of these cases, they end up primarily settling before they may even ever see a courtroom. But in the case that they do end up going to court, what has been one of your techniques that you've employed to really see success in that area?
Well, I think that it's a collaborative approach, right? You can't do it on your own. And so you have to be able to, you know, share the work and delegate the work with people that you trust. So I'm fortunate enough here to be surrounded by, we are a family practice and kind of an extended family too. And so we are all working together towards a common goal. And we all sort of have different strengths and weaknesses, and we play to those strengths. But I think trying to find commonality is really the goal in connecting with the jury, finding out how they value personal loss, and playing to that, not trying to change the way they feel, but learning about the way they already feel and playing to that.
That feels really rooted in, obviously, I mean, jury selection process itself is just integral to either, whether it's civil or criminal. When you talk about handling a case from beginning to end, obviously that at the end, that obviously would be trial itself. Are you, like, when you accept a case, are you beginning to think early on about the story that you're going to tell, or the ideal juror for that case, or what an opening statement might even look like? I mean, are those things that sort of just start spinning in your head that early?
Yeah, I mean, I think you always have to look at, how do you value the case? And the way you value a case is what 12 people might decide the case is worth. So you always have to keep that in mind. And I think there's this ebb and flow as you work up the case. It's, clients want to know how much their case is worth, but the reality is the value of that case is dynamic, and it changes over time as you conduct discovery and you take depositions and learn more, and, testimonies given. And it's not, it's not a science. It really is an art, and there's so much gray area. And the goal is to try and figure out what that sweet spot is and to measure the risk tolerance of your client. And you learn that with experience, with time.
You mentioned the deposition process there and conducting proper discovery. Is there anything that you do with your depositions that really works uniquely for yourself or for anyone else in your firm?
It's interesting because if things have changed a lot with technology now, with remote depositions, and everybody's on Zoom, and I think you lose a lot of the connection and the cadence. I think the fact that more depositions are being video recorded is great, because, and you learn this in cases that go to trial, but it is not always what you say that shows up on the written transcript, but it's how you say it, right? It's the pauses, it's the emphasis, the believability. You can't get that from just reading it. And so I think the fact that we're doing more and more of this is a good thing, but there are minuses. You do lose a little bit of that connection, which is, so ideally you want to be doing it in person, so you can gauge that back and forth and develop that rapport with the witness, and then decide where you want to apply pressure and leverage and try to get more.
I kind of want to stay in this space here for a second, Tyler, because your practices obviously spanned a number of real tech inflection points as different things have affected the legal practice. You just mentioned one, right? The ability, Zoom is an amazing asset, but it also has its minuses. What are some other things like that you've tech-wise that you've either incorporated into your practice that you do see the pluses and minuses of, or tech that you really feel just the pluses or just the minuses? I'm interested in that landscape for you.
I think the big red flag in the room right now is AI, right? It's how do we use it? How do we use it responsibly? And as a lawyer and actually as a parent of two teenage kids, I'm a big believer in that. There's a problem with technology, right? And the problem is it makes information accessible to everybody, but that does not mean you have knowledge or you have wisdom, right? That comes from experience. And so while you might be able to regurgitate something, but knowing its application and understanding it is totally different. So, I mean, as AI evolves, we're getting into a better place, but AI is only as good as what you feed it, and you have to know what you're feeding it, so you can trust the outcome. But I am concerned that a lot of people just, and it's easy to fall victim to it. They just want AI to generate something, and it's really not work product. It's just stuff, and then it gets finalized and put out there. So I think one of the things that I'm starting to do is I've taken, all of my old files since I've started practicing, and I've converted everything into text searchable OCR documents. And so what I'm working on doing is developing a platform for myself so that I can measure, based on my prior work product, and use that as a foundation for the AI technology, so that when I use it, it's going to be a reflection of my formatting, my styling, the points and authorities that I believe are applicable, and the parts of those authorities that carry the most weight. So I think I'm trying to be forward thinking. I mean, right now, I think it's great for extracting data, for summarizing documents, but for more complex legal applications, we need to be careful.
It's a valid point, and definitely can pose some risks, particularly with hallucinations and how people take onto that and use it as fact, which can be dangerous.
Yeah, I think we've seen a bunch of judges issuing sanction orders, and I saw one recently where a judge even commented that he was intrigued and almost persuaded until he finally realized that those were in fact hallucinations. So that is how enticing this AI technology is. So, you just got to be, careful, and you've got to learn. You can't just rely. So I think it's going to be really important for the next generation of lawyers, especially with what we're seeing with big business taking over, private equity trying to take over law firms, is that you have to strive to become good at your craft. And if you keep that compass and your moral compass straight, you'll be fine no matter what. But it comes down to that, being good at your craft.
I'm curious, how do you talk to your kids about this? I mean, I'm maybe the question beneath the question there is you're seeing the effect firsthand on what this can do in the legal sector and what it means. It can churn out product that looks quality, but it doesn't mean you intrinsically understand what that means or how to then stand up in front of a jury and tell that story convincingly. There's still soft skills around that it's not going to replace. Are you seeing things in your children or younger generation that they're really good at or really weak at now because of this technology that's around? And how are you addressing that?
Yeah, I mean, I think, and to make things worse, I think the COVID pandemic, right? I mean, what all this technology does is it stunts human interaction and the human experience. And so I think it's important, at least for me as a parent, we're talking about kids, is making sure they understand that, true knowledge comes from experience and from human interaction. And you're not going to get that through, Snapchat and Instagram and Facebook and AI. You need to go out there. And I think my biggest concern is that as a result of that sort of heightened level of technology, I think kids are losing their grit, and that everything is so easy and accessible. I mean, you can get your food delivered from wherever you want. You can find out the answer to any homework question with just a few keystrokes. It's not there's no hardship there. There's no difficulty. I mean, I remember it used to be, for me, I needed to do a school project, and I had an Encyclopedia Britannica with a few letters of the alphabet missing, and then I'd have to go and ask the oldest person in my family who might know the answer, right? I mean, so you had to hunt for it. It's different. So I think a little bit of that is good.
Have you seen younger attorneys at all be affected by this? Because a big portion of law, I think, is the soft skills, right? Being able to speak with clients, prospects, and really understand how to engage with a person very well. But with the advent of AI and our continued reliability on technology, some of that I feel might get lost in the wind. Have you seen that be the case at all with any younger attorneys?
Yeah, I think sometimes it prevents them from being as sympathetic as they should. And sometimes they just need to remember that listening is a skill, and just letting people talk, and especially dealing with conflict management. I think I see it a lot where you have a client that has an issue, and a lot of times they just want to be heard. And then I remind them, that the best thing you can say to, a client that's upset or somebody that's angry is to just tell them that you agree. Say, I agree. I agree with everything you're saying. Let's talk about how we're going to solve it, what we're going to do next. A lot of times people just want to have that validation and that sense of support. So I think those are, the few tools that I give to the people that are working around me so that we can maintain, that level of harmony with our clients and continue to move the cases forward.
How do you coach that, Tyler? I mean, it's an interesting thing to teach, like actually in this moment, less is more. And sometimes that level of empathy that just says, if I was in your shoes, I'd feel the exact same way, and really, really, really authentically mean that. That seems like a deep thing to actually teach someone.
I think you just have to do it by example. You have to set the standard by doing it yourself. They have to watch and they have to see it. And then they go, wow, that client really calmed down after you did that, and feels a lot better about the case and about you. And a lot of times, we bring the clients in, or we'll do it by Zoom instead of over the phone. They need to have that feeling. That sense of validation, especially in personal injury cases, right? This is arguably the worst time of their life. They're going through, financial pressures. They're dealing with difficult medical decision-making, and they need to know that their case, the legal issues surrounding what happened, is being taken care of. They don't have to worry about that. They can check that box off. So I think, by listening to them, you play a little, psychology, and you comfort them, and then I think they're far better off. And my paralegals, my staff, they see that, and then they incorporate those skills on their own.
Going deeper into personal injury, what are some common misconceptions people have when it comes to personal injury law that you've just noticed are pretty rampant? And if you could set the record straight, what would it be?
Not every case is worth millions. Right? I mean, and I think I talked about this earlier. Everybody's got a unique human experience, but I hate to break to you, not everybody cares about your experience as much as you do. In fact, you probably care more about your human experience than anybody else. So, it's, you see a lot of, publications and shameless self-promotions of lawyers that get these nuclear verdicts and these huge settlements, and those are well-deserved. But that's not something that occurs all the time. Not every case is worth, millions and millions of dollars. So it's that sense of entitlement that you need to address early on, and that sense of realism, and that can only come from the lawyer. And if the client's not willing to accept that early on, then that's a red flag.
High profile, high dollar verdicts. These are obviously huge, like the thrust of a lot of personal injury lawyer marketing campaigns. If you are, let's say, you do sort of an initial consultation with someone, and this is not a case that you are going to take on. What kind of questions would you advise someone, or what kind of things would you be advising someone to look for? I'm assuming you might refer it out, but let's say you're just being a little bit more abstract. What kind of things would you advise someone to be looking for, red flags or otherwise, when they actually go and interview and meet with a personal injury attorney?
A lot of times, I tell clients to keep it super simple. Okay. Keep it simple. Especially if somebody comes in with, a complex medical history involving, let's say, a medical malpractice case, right? When an attorney is listening to a potential case, they want to get straight to the point. For example, what did the doctor do wrong that fell below the standard of care in the community? Or what was it that, who is it that you want to sue and why? What did they do wrong, right? Just because you fell on somebody's property and were injured doesn't mean that they're responsible, right? So you got to tell the potential client what it is that the lawyer is looking. So sometimes, if I reject a case, I also tell them, I say, you need to write it out. And then the next lawyer you talk to, you can present it to them, because it sounds to me like you're going to have to talk to a lot of lawyers. So it's good for them. It's good for the lawyer.
When it comes to these massive cases, and that you have one, like there is definitely potentially a very large settlement or verdict that can come out of this. What processes do you follow with your team to make sure that all your T's are crossed and all your I's are dotted? Because I'm sure that it requires some type of special attention.
Yeah, I think what sets us apart is we're really proactive with our investigative work. It really depends on the case, but in terms of hiring the right investigators before the case is even filed, document the scene, photos, measurements, obtain any video from adjacent property owners, downloading EDR and black box data from motor vehicles, interviewing witnesses before memories fade, stuff like that. You can't just rely on the investigation of local law enforcement to do the work for you. You gotta do it for yourself. And for your client. And then as the case goes on, it's about, you file and you serve the lawsuit. Second, you get a responsive pleading from the defendant. Get your discovery ready to go. They're going to want extensions, so you got to hit it hard. Subpoena all records from third parties that you're going to need to prosecute your case. And before you even file the lawsuit, make sure your attorney service goes out and gets all the medical records on your client. Past medical records. Do your due diligence on your own client. I run background checks on all my clients. I run ISO claim searches on my clients to figure out what their past PI and workers' comp claims are. I want to know all the problems with my client before the other side finds out, and I have to assume they're going to find out everything.
With AI, there's a number of reasons, I guess maybe even before AI, we've been talking about in sort of big law, the death of the billable hour for eternity. I'm wondering if there's been a similar conversation, or if there's an analogous conversation around contingency fees and how you see that sort of bearing out down the road as well.
Yeah, a couple of things. It applies differently, as you pointed out, to the defense side as it does to the plaintiff side. I think ultimately the way you're going to see it evolve on the defense side is it's overbilling if you don't use AI, that it's such an integral tool. You can't be spending a ton of man hours summarizing records when you can use AI to do it, and it takes minutes. So I think that becomes something they have to consider. And then on the plaintiff side, depending on what the AI needs are for a particular case, how much do you spend on that? Because it's money that's coming out of your client's pocket at the end of the day. And I think you need to be upfront with your client about those needs and those costs, because it's sort of a new category of expense. And I think the clients need to understand how important it is to represent them efficiently. And it actually saves money. You're spending a little bit to save more. So I think, I think it's evolving, right? Some people use third-party vendors that basically just use their own proprietary AI. Some lawyers use AI to supplement their own work. And it just becomes on a case-by-case basis or task-specific basis, and you've got to determine what you need, what serves your needs best. But I think AI, this is just the genesis of it. It's going to become more powerful, exponentially so, and it will not replace what we do. I don't think there's going to be an AI robot, realistically litigating cases in the courtroom, but although I've seen it on YouTube. So I think we're okay for now. Again, it comes down to honing your craft, keeping a strong moral compass, do a good job, and the chips will fall where they fall.
Do you think there's going to be a new level of kind of transparency with your clients now that AI is becoming more integral in how attorneys go about their day-to-day? Do you think there's going to need to get like some type of approval from a client saying, is it okay if we use an AI software to manage your case or manage certain parts of it?
No, I don't think it requires client consent. I think what you're going to see in terms of transparency is the clients using AI to quarterback every decision you make, right? Everybody becomes their own legal expert. It's like, they come back with these long paragraphs of, AI write-ups about what they should be doing. And so it makes our job harder. And I would imagine it's similar to in medicine, right? You've got clients that are looking up their medical condition and they say, I think I've got such and such because I went on Google and I found, this information. And then you learn it's not so simple.
Yeah. It's like the modern version of a jailhouse lawyer.
And so you know what they say? What's the expression? A little bit of knowledge, a little bit of knowledge can be bad. So, and again, that's why, again, that level of trust with the client is so important early on, right? You need to show them that you're more than just some AI extension. You're an actual skilled professional, right? And there's no replacing that. So that comes early, and I think that's becoming even more important with the AI technology.
I always say to my students or to younger criminal practitioners that I've hired or worked with, I mean, the strongest thing that we have, the biggest power and most leverage we have is not just our ability to go to trial, but our sort of lack of fear in doing so, our willingness to do so. I've also heard other practitioners describe trial as a last resort. If all else fails, we'll go to trial, which isn't necessarily the way that I think about it. And that seems almost like rooted partially in fear or whatever it is. How do you size this up? I mean, what is your assessment of the role of trial and how you consider it and how you even discuss it from the earliest moments with your clients?
I mean, I think that's the beauty of the system we have, is that courtroom is the grand equalizer, right? It doesn't matter how big that defendant is. It could be General Motors, it could be Philip Morris, but there's only one person on their behalf that can be speaking at a time in that courtroom. And I remember when I first started out, I wanted to work for this lawyer that had gained a lot of notoriety doing crashworthiness cases. And he was trying a case against Philip Morris. And I went to his trial every day. And I said, I want to work for you. I want to learn to do what you do. And he said, I'm not hiring. And so I went for about a month, every day, just watching that trial. And eventually he had me holding up exhibit boards, and he won that case, and was on behalf of just one person. And he won it for $28 billion. It's the largest verdict on behalf of an individual plaintiff. The judge ultimately issued a remittitor of 99.9% and brought it down to 28 million. Oops. But I mean, that is the perfect example of what can be accomplished in a courtroom. And that's where, I mean, that's like the grassroots of where laws are made, right? And that's where it starts. So it starts with one person. Is the courtroom a last resort? Sometimes, but sometimes it's the only resort. Especially when you're trying to carve out, a new path, a new way. You're trying to do something that hasn't been done before, and you want other people to be able to do it after you. So that's really important. It's not a perfect system, but it's a system that I believe in.
One key part of this you mentioned in the trial prep was hiring investigators and being extremely thorough. How do you
Yeah.
know who to hire, and how do you build a relationship with these people? Because I'm sure, like, for example, an investigator, I'm sure you've worked with more than a handful of them. How do you identify ones that meet all the boxes for what you're looking for in a case?
I've been using the same investigator for over 20 years.
Wow.
So yeah, I'm not going to tell you who it is. uh, that's so, that's it. There is no choice. It's just one person in their team. This is a relationship business. You have to decide who you want to develop those relationships with. And what goes around comes around. So people that work here are like family. The investigator I use has been with me since the beginning. And I think that sort of loyalty is.
Tyler, again, I want to go back to this. So much of what you've talked about, there's like a sort of a psychological and philosophical element to the way that you're going about your practice in a way. I mean, the things that you're thinking about, communication, the silence, the way that you tell a story to a jury, these are, you're not going to really find them. It seems like it's something that you've really prioritized or learned or are really important to you. Okay, so my question really is, what is it that you want to be known by? I mean, you've got these huge verdicts. You've obviously been tremendously successful. Do you like that being a defining part of who you are, or is there other things that are the way that you're described that matter much more to you?
No, I mean, being a lawyer is what I do, but it's not who I am, right? And same thing goes for the clients. What they do, it's not who they are. There's more to it, and I think those are the layers that you have to peel back with these people. For example, I use for my case management software, I use FileVine. It's a great cloud-based system. But what I do is on each file, instead of seeing a file folder, I actually have the picture of my client. So every time I open up a file, I see them, right? And so what I try to remind myself to do is when I'm communicating with the other side, whether it's a defense attorney or an adjuster, what have you, I'm, sometimes on like my demands and things like that, I'll put a picture of my client there, just a headshot, on the first page. I'm trying to bring that human element, that connection, and tell their story, because I think that is what inspires people, right? And I try to explain early on with my clients too. We talk about the psychology of it. We talk about what inspires people to help other people, what inspires people to give large awards, and it is never the person that whines and complains, right? There's a certain amount of stoicism that you need to have. I don't, by any stretch of the imagination, tell my clients to, underreport their symptoms or to diminish their symptoms. I mean, they have to tell it like it is. But whenever the defense attorneys ask my clients in deposition, for example, is there anything else they'd like to say? I always tell them to say, I'm grateful. I'm grateful for being able to have my left arm, right? I'm grateful for being able to do this. I think that's what inspires people, not the people that just blame everything that's going on in their life because of an injury that they have. And I think that is sort of an important lesson for us all, right?
We always ask this at the end of our conversation, and that is, what is your hottest take on the industry right now?
I think my hottest take on the industry right now is you need to become good at your craft. That's my hottest take, right? You've got all this noise out there. You've got the technology, you have the AI, this, that, the other, but you need to expose yourself in the courtroom to other lawyers, right? Watch, listen, learn, read, join the listservs, right? Get engaged in these other communities around you and learn from other people, because pretty soon you're going to be the person kicking that knowledge down to the next generation below you. And with technology and big money taken over, you need to make sure that you have your own value. And the only way to do that is by developing your craft. So develop your craft, and there's always room for improvement. That's my take.
It's a fantastic take. Well, thank you everyone for tuning into Between the Briefs, brought to you by Steno. A special thanks to our guest, Tyler Barnett, for sharing his valuable insights into personal injury law, his career highlights, and the role of legal technology in improving client outcomes. And of course, a big thank you to my co-host, Joe Stevens, for another great discussion.
Yeah.
Thanks, Joe. Thanks, Adrian.
Of course.
Thank you, Tyler. And stay tuned for more thought-provoking discussions at the intersection of law, technology, and innovation. We'll see you next time.
Up next on Between the Briefs.
We found significant improvements in efficiency. Where we really saw differences in how human lawyers who had these tools performed was in the quality of their work. Not only were the folks who participated in our study performing and providing us with legal work really quickly relative to those without AI, but they were providing better work.
Stay tuned for the full interview coming to you soon. Between the Briefs is brought to you by Steno. To find out more about Steno and how we combine exceptional court reporting and litigation support services to deliver a superior litigation experience, visit steno.com. That's STENO.com. And then make sure to search for Between the Briefs in Apple Podcasts, Spotify, or anywhere else you get your podcasts, and click subscribe so you don't miss any future episodes. On behalf of the team here at Steno, thanks for listening.